Hello, everyone, and thank you for joining the broadcast. You know me, I'm Patrick John McGinley, coming to you live, so to speak, from Winter Park, Florida. As you know, I'm a member of the Florida Bar, a member of the District of Columbia Bar. Proud to be a member of those two bars. Been practicing law for over 24 years now. My goal with these broadcasts is always the same. My goal is to help you take a deeper dive into the model rules of professional conduct, so that whether you're studying for the NPRE, whether you're studying for a bar exam, whether you're just trying to brush up on your ethics, I could be of help to you. I've already guided you as to where you can find that overview. I've provided you with the materials from others that give you a great overview. But in these broadcasts, my goal is to take an even deeper dive than those materials. So when I talk to you, talk to you with respect. I talk to you as someone who has at least a modicum of knowledge when it comes to professional responsibility. And I try to highlight for you some of the knowledge you already have and to build on that knowledge in order to take this deeper dive. So today, what we're going to do is take a look at the Model Rules of Professional Responsibility with this theme. Our theme is public service and integrity of the profession. So we're going to pull out some of the rules from the model rules that advance our theme. In so doing, on occasion, we're going to take a look at actual rules, not just the model rules. I'll focus, of course, on the rules regulating the Florida Bar because I'm a member of the Florida Bar, or the rules regulating the District of Columbia Bar because I'm a member there too. Obviously, there are far many other states I could have taken a look at, but I'm not a member of those bars. Who am I to lecture on those? So, as you know, for the past 24 years, it's been my great pride and my great honor to defend my fellow lawyers against bar grievances, ethics complaints, ethics investigations, and rendering ethics opinions. It's something I know and love, but it's something I know and love from practice. Florida, DC, it's where I'm licensed, so I want to stick to my areas of expertise as I expand on these model rules and help explain them to you. So our theme then, public service and integrity of the profession. What specific rules will we be looking at? Well, we'll be looking at most of Chapter 8 of the ABA Model Rules. Chapter 8 talks about maintaining the integrity of the profession, our profession, the profession of the practice of law. And I'm going to focus in on these four rules. Rule 8.1, which talks about bar admission and disciplinary matters. Rule 8.2, which talks about judicial and legal officials. Rule 8.3, which talks about reporting professional misconduct, where those reports come from, who's obliged to make those reports. Rule 8.4, that Rule 8.4, that catch-all, if you will, that talks generally about misconduct. We're leaving out just for now Rule 8.5 with disciplinary authority and choice of law. We're going to focus instead on rules 8.1 through 8.4. While doing so, I'm also going to tie into our theme of public service and integrity of the profession. ABA Model Rule Chapter 6. Chapter 6 talks about public service. And Rule 6.1 is voluntary pro bono publico service. Rule 6.2 is accepting appointments where you've been appointed as counsel. So that's a lot to cover. But wait, there's more. A little Ron Popeil reference there. Remember the late, great Ron Popeil? Anyway, but wait, there's more. As I mentioned, I'll also throw in some references to the rules regulating the Florida Bar. And to keep track of those, the rules regulating the Florida Bar are in Chapter 4. So a Florida Bar rule looks a lot like a model rule, but it's got a 4 dash out in front of it. What do I mean by that? Instead of a Rule 8.4, in Florida, we have Rule 4 dash 8.4. Instead of Rule 8.1, we have 4-8.1. Instead of Rule 6.1, we've got 4-6.1. I think you're catching on to the pattern at this point. So the 4 comes out front here in Florida. Florida, being real rules, have based themselves upon the model rules, but have tweaked them, sometimes ever so slightly, sometimes dramatically. And citing those rules and explaining them from time to time will help you have a better grasp and understanding of what the model rules cover and what they don't. So I'll reference those from time to time. But wait, there's more. I'm also going to throw in Model Code of Judicial Conduct 2.15. After all, some of these rules that we're going to talk about here, they talk about the judiciary, so we'd be remiss if we didn't pull in Model Code of Judicial Conduct 2.15. So you see where we're going? All right, that's the roadmap. With that roadmap laid forward, let's get started. Let's start not at the beginning, but let's start at my great nemesis. Model Rule 8.4, which in Florida is 4-8.4. Why would I call 8.4 my nemesis? Well, remember, I take great pride in defending my fellow lawyers against bar grievances and ethics complaints. It's this 8.4 that allegedly is not void for vagueness, but certainly could be described as a catch-all that pulls in to the rules of professional responsibility so many disparate things and items and behaviors that aren't explicitly in the rules. Thanks to Model Rule 8.4, if bar counsel, that's what I refer to as our prosecutors of ethics violations here in Florida, if bar counsel really wants to bring charges against you but doesn't have a rule on all fours, doesn't have a rule exactly on point, very often it'll be Model Rule 8.4's equivalent here in Florida, 4-8.4, that bar counsel will be charging you under. So what is Model Rule 8.4? Model Rule 8.4 talks about misconduct. And under that model rule, it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Now, that's a bit vague, but not too vague. Obviously, a lawyer in the course of representing a client shouldn't do things that interfere with his role as an officer of the court. We are more than just the foot soldiers of our clients. We are more than just a hired gun. We have an ethical obligation not only to our clients, but also to our profession and also to the integrity of the tribunals, the courts, the judges that we appear in front of. To call ourselves officers of the court and have a straight face while doing so, we've got to acknowledge that our obligation is greater than just that of a street fighter blindly trying to advance the goals of his or her client. We also have to refrain from conduct that is prejudicial to the administration of justice. That should go without saying. And perhaps for that reason, it is stated very broadly in Rule 8.4. When the National Conference of Bar Examiners are to test on such a thing, or perhaps when I write a final exam as my role as a part-time adjunct, we'll take into account situations where the lawyer has interfered with a court proceeding, where the lawyer has not let the court proceeding run its course in an impermissible way. Of course, there are permissible ways for trying to stop the inevitable outcome of a court proceeding. It is not a violation of Model Rule 8.4 sub D, which you see here on the big board, to file bankruptcy on behalf of your clients in order to get an automatic stay to stop the litigation. It is not a violation of Rule 8.4 sub D to file an interlocutory appeal or an extraordinary writ or some other means of involving the appellate court that is available to you under the rules of procedure or the rules of appellate procedure. These methods arguably could be prejudicial to the trial judge continuing her or his work, but the applicable statutes and rules of law permit these attempts if the litigant has a good faith basis and is not raising a frivolous argument. So we can't simply say that if a lawyer is trying to stop the inevitable loss in court, that lawyer has violated Model Rule 8.4. We would need facts beyond that in order for there to be a violation, because there are good faith arguments that can be made to try to stop the proceedings. Likewise, the law may be on all fours, and all fours might be against you. For example, there could be binding case law precedent that says you lose. Is it a violation to hide that precedent from the presiding judge, the presiding tribunal? Yes, under several rules, not the least of which would be Model Rule 8.4. You have an obligation to acknowledge accurate law. With that said, under Model Rule 1.2 and under Model Rule 8.4, a lawyer can be permitted to make a good faith argument for the reversal of existing law, or a good faith argument for the modification of existing law. I would recommend, as a practice pointer, that you present the argument as such at the time you're making the argument, for two reasons. First, to oblige your obligations as an officer of the court to cite to and to reveal that statute or binding case law precedent that is adverse to you. Second, as a practice point, to protect yourself from a charge by your opposing counsel, or a charge by the presiding judge or officer, or a charge by bar counsel that you were caught red-handed and only after being caught tried to backpedal and pretend that you were making a good faith argument for the reversal or extension or modification of existing law. Say it up front, say it early, say it loud, get it on the record. That way you can't be accused of having been caught and using that exception to try to justify your behavior. So do it up front. Model Rule 8.4 has its equivalent in Florida Bar Rule 4-8.4, and there a lawyer shall not engage in conduct in connection with the practice of law that is prejudicial to the administration of justice, including against litigants, jurors, witnesses, court personnel, or other lawyers. Now, you could accurately say that this is additional text that Florida has added to Model Rule 8.4 that doesn't exist in the Model Rule. But I would respectfully suggest to you that the Model Rule, being concise and broad, also includes all of this, even though it wasn't in the text. You can't be so obnoxious and dastardly as to an opposing counsel so that it interferes with the proceedings. You know, we all feel anger sometimes, and we all take offense sometimes. And one of those times when you feel anger or take offense might just be in a courtroom, might just be due to the actions or behavior, statements of your opposing counsel. Hey, there's a time and a place for everything under the sun. There's a time and a place to yell and scream, and there's a time and a place to keep your cool. And the courtroom, my friends, is the place to keep your cool. So let's not be rude and obnoxious to our opposing counsel, especially not when doing so would disturb the decorum, would disturb the courtroom, would be a problem. So let's keep that in mind. Let's view that as more than just professionalism. Let's view that as an obligation under 8.4. That's true, of course, for jurors. That's true, of course, for witnesses. That's true, of course, for court personnel. It's true, of course, for parties. You know, if you're in litigation, sometimes your client is not happy with the other side, not pleased. And there's that temptation because you know your client would yell and scream at the other party if they could. There's that temptation for you to do the same. Maybe the temptation is because you want to look like the tough guy. You want to show your client you feel the empathy, the sympathy, the same anger, the same feelings. But our profession is greater than that. We're not boxers. We're not street fighters. We are the difference between needing to have a street fight. You hire a lawyer instead. You don't take matters into your own hands. And likewise, we should be an alternative to these kind of arguments and bickering. So come on, you're deposing the plaintiff when you represent the defendant, or you're deposing the defendant when you represent the plaintiff. You don't have to mistreat the other side. Indeed, if you do, if you have an aggressive bar counsel, and you certainly have a very broad rule like this, you might find yourself facing a bar complaint. So don't do it. Follow the golden rule. Do unto others as you'd have them do unto you. Just because you're a lawyer, you don't have to abandon the golden rule. The rules of lawyering and the golden rule are entirely consistent. There's no need to violate one in order to uphold the other. Model Rule 8.4 tells us it is professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. This is the language of the model rule. And maybe this is the language of the golden rule too. Hey, do unto others. Now, with that said, how might bar counsel use 8.4? Well, obviously, in the practice of law, you need to be a good citizen. You need to be a good lawyer, and you need to be a good neighbor. But 8.4 can bring in behaviors that happened outside the practice of law. Imagine, if you will, you're a licensed lawyer, and it's a Saturday, which maybe in your particular specialty means a day off. Sorry, criminal defense attorneys out there. But imagine it's a Saturday and it's your day off. And you're out mowing the yard. And your neighbor's across the fence. And your neighbor's dog has left behind some treasure for you on your lawn yet again. And you're mad, And you're out there in your yard work and you share some words. I don't know, God forbid, maybe even you swing some fists between you and your neighbor. Okay, can bar counsel charge you under Rule 4-8.4 with violating the rules regulating the Florida bar? Answer is yes. What, McGinley? The answer is yes. Oh, it was a Saturday. I was mowing the lawn. It was my day off. I was not practicing law. I did not have on my lawyer hat. I wasn't even wearing my lawyer clothes. I wasn't doing lawyer work. I don't represent my neighbor. I've never been his or her lawyer. She's never been my client. I wasn't in a court of law. All these things sound like defenses, but I'm sorry, my friend. None of them are. None of them are. As you're being booked for assault and they're taking your mug shot there on a Saturday, you're going to find that mug shot also has an exhibit sticker put on the bottom of it when bar counsel files a bar grievance proceeding based on that same event of moral turpitude and of criminal behavior. It doesn't matter. All those things I mentioned. It doesn't matter that it was a Saturday. Doesn't matter that it was your day off. Doesn't matter that you weren't practicing law at the time. Doesn't matter that you weren't dressed as a lawyer. Doesn't matter that you weren't in a courtroom. Doesn't matter that you weren't in front of a judge. Doesn't matter that that wasn't your client. Doesn't matter that that was never your client. Doesn't matter that it is not connected to the practice of law. It's connected to you. It's connected to you as a lawyer. And it's connected to the question of whether you belong in our profession. And the behavior I just described to you is not acceptable behavior for a member of our profession. So yes, Bar Counsel could charge you under Rule 8.4. Arguably, Bar Counsel should charge you under it. So you can take off your lawyer hat. You can have your days off, but you can't be dishonest. You can't be attacking the integrity of our profession. You can't be less than an honorable citizen. So come on. Do unto others as you'd have them do unto you. So that's the catch-all, if you will. That is Model Rule 8.4. That is why a lawyer who wasn't being a lawyer but didn't file her taxes can get charged with a violation of the rule regulating the Florida bar, even though she's not a tax attorney, even though it was her personal return. That's why a lawyer who gets arrested for shoplifting, wasn't practicing law at the time, still can be charged under the rules regulating the Florida bar. That's why a lawyer who has a business venture, which is not part of their law practice, which is not part of their law firm, but which they use to perpetrate a fraud, nevertheless can be charged for violation of the rules regulating the Florida bar or under the model rules. You see, you might mentally try to draw a line between whether the action was you as a lawyer or whether the action was you as a non-lawyer. But what we're looking at here is you. What we're looking at is your fitness to practice law. And that's true not only when you're applying to become a lawyer, but as you continue to practice law. There's many a case law in many jurisdictions, Florida and District of Columbia included, that reminds the public that the practice of law is a privilege, not a right. What's meant by that? Isn't a license a property interest under the law? Sure it is, but your license is contingent upon your continued fitness to practice law. So these extra legal, outside the practice failings, which show moral turpitude or which show that you're unfit to keep that license, they're sufficient for bar counsel to bring bar charges. They're sufficient for you to be disciplined by the disciplinary authorities. So when it comes to the MPRE, don't fall for that misleading fact pattern that makes you think, oh, it was bad behavior, but he wasn't practicing law at the time. Likewise, when you're practicing, don't fall into the mental failing, the mental trap of thinking, once I take off the tie and the jacket, I can be as dastardly as I want to. Not true, my friends. Not true. So that's Model Rule 8.4. Let's take a look at Model Rule 8.3, reporting professional misconduct. So this is how disciplinary authorities, such as bar counsel, are alerted to the fact that it's time to take action against one of their members, that it's time to open an ethics investigation, or perhaps even that it's time to bring charges. So that's what we're talking about in Model Rule 8.3. Model Rule 8.3 sub A tells us this: a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that other lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. Now let's parse the words, but also let's make reference to the official commentary that helps us parse the words. First, let's not miss the word shall. As you know, shall means will, and will means mandatory. It means you have to, means must, means gotta do it, means an affirmative obligation. With that acknowledged, however, when does this affirmative obligation arise? Is it true that a lawyer is obliged to report every obligation of the rules? The answer is no. The answer is no. We know the answer is no because the official commentary in its paragraph 3 to Model Rule 8.3 tells us so. To quote it exactly, got my reading glasses on, so you know I'm quoting it exactly. If a lawyer were obliged to report every violation of the rules, the failure to report any violation would itself be a professional offense. Such a requirement existed in many jurisdictions, but proved to be unenforceable. This rule limits the reporting obligation to those offenses that a self-regulating profession must vigorously endeavor to prevent. A measure of judgment is, therefore, required in complying with the provisions of this rule. So yes, shall means will, shall means must, shall is an affirmative obligation. But that affirmative obligation is limited to those instances that raise a substantial question. A substantial question as to what? As to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Okay, McGinley, help me understand. Perhaps a hypothetical might help. You've been in the same town with your opposing counsel for over a decade. You've had many a case against her. She's always been on the up and up. But something just went wrong. There was an ethical breach here. A technicality, if you will, but certainly a violation. You pick up the phone, you respectfully point it out. She immediately remedies the situation. Any harm that had been done is now undone. Okay. Shall means will, shall means must, shall is an affirmative obligation. Under my hypothetical I just gave you, must you report that failing? The answer is probably not. Probably not, because the question isn't whether there was a failing. The question is whether the failing raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness. In my hypothetical, you've litigated against that particular opposing counsel for a decade, and there's never before been a failing. The failing you just saw was a failing indeed, but arguably could have been a technicality, and certainly, when pointed out, was remedied and remedied thoroughly. It was a failing for sure. But is it a failing that raises a substantial question as to that lawyer's trustworthiness, honesty, and fitness as a lawyer? Under my hypothetical, probably not. So there, hopefully that helps you to see what the quoted language from the official commentary of Model Rule 8.3, paragraph 3 was attempting to illustrate when it says, if a lawyer were obligated to report every violation of the rules, the failure to report any violation would itself be a professional offense. That's not the case. Okay? So only those violations that meet this high criteria, that raise a substantial question, not just a question, but a substantial question, as to the lawyer's honesty, trustworthy, or fitness. Those are the only mandatory obligations you've got when it comes to you as a lawyer alerting bar counsel or the authorities that regulate the profession about a shortcoming, a failure to abide by the rules of professional conduct. So that's what we're talking about when it comes to lawyers, policing lawyers. But don't forget, we are a self-regulating profession. And that varies from state to state. Again, I'm not licensed in the state of California, so please don't interpret me to be giving you California advice. But as I understand it, it's a statute in California when it comes to the rules of professional conduct. That's not the same in Florida and DC. They are, at least in Florida, they are part of the court rules. They're not a legislative enactment here in Florida. So with that noted, Model Rule 8.3, subsection B, says the following. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. Two things to note are the same two things we noted earlier when it came to a lawyer reporting another lawyer. When it comes to a lawyer reporting another judge, the first thing we note is the same. We see the mandatory shall. Shall means will. Shall means must. Shall means an affirmative obligation. But the limitation, again, is there. The violation raises a substantial question as to the judge's fitness for office. Substantial question. Judges are human. Humans make mistakes. Imagine this hypothetical. Statute is plain as day. You even included a verbatim quote from the statute in your written motion. And there was oral argument on your written motion. You quoted it verbatim, as well as explaining it in plain English. But nevertheless, the ruling does not comport with the statute. The ruling is a clear error of law. The conclusion of law reached by the judge is contradicted by the statute that you gave the judge in writing, that you read to the judge out loud, that you explained to the judge in plain English. Do we now report this judge to the authorities that regulate judges in that jurisdiction? Probably not. If I phrase my hypothetical correctly, certainly not. I was going for certainly not. I'm hedging my bet with probably not. But hey, judges are human. Judges make mistakes. It's why we have appellate courts. Because judges are human and judges can make mistakes. Look, a judge acting in good faith can misinterpret a statute. Hopefully next to never. Hopefully it's a minor aberration. Hopefully it hardly ever happens. But judges are human. It can happen. That would not be an example that raises a substantial question as to the judge's fitness for office. How about this? This one I recently saw on the news. I think it was New Jersey, if I remember correctly. I grew up in New Jersey and went to high school there. So this is not intended to be negative to the great Garden State. Love you, Jersey. But in New Jersey, apparently there was a judge at a hearing for, I believe it was a restraining order. The victim of a sexual assault. The judge intervened with some questions of the judge's own. The questions were quite specific as to the sexual assault, what occurred thereupon. After the hearing, the judge was back in chambers with other judicial assistants or not in a public place, with coworkers, made some comments that were interpreted along the lines of, "Did you hear me out there? I'm good with the sex talk." I'm paraphrasing, something along those lines. Since I'm paraphrasing, we'll call that a hypothetical. Hypothetically speaking, would you have an obligation to inform the appropriate authority that regulates judges? Hope you will agree that the answer is yes. In this hypothetical that's based on what happened, it's my understanding that that judge has been removed from the bench, which I think we should all agree was the right outcome. So judges are human, but that doesn't give judges rights that appear in front of the judge. You know, I've been practicing for almost 25 years, 24 years in a few months, but hey, who's counting, right? And I've been blessed to appear almost always in front of a great judge, but some were greater than others. And some of those judges, they had different attitudes than others. I guess the judges that I personally respected the most were the ones that came to the bench with, dare I say it, a customer service attitude. Is that too far a stretch? They came to the bench knowing they had a job to do, that they could do it respectfully, that they were there to serve the public, that ultimately they had to make a decision that was adverse to at least somebody in that room, if not everybody, but did that while maintaining proper judicial demeanor and sharing proper respect for the witnesses, the parties, and the lawyers that appeared before her or him. It's the kind of judge that I think is the cream of the crop, the best of the best. Obviously, judges are human. They get mad, they get sad, they react. But in the end, professionalism can set a good judge apart from a great judge. And that's the kind of judge we all need to be judged by, a great judge. So Model Rule 8.3 does create an obligation from time to time for a lawyer to bring charges, or at least an inquiry, or at least an accusation against the judge. And hey, that is a difficult spot to be in. It's not an enviable spot to be in. Imagine yourself in a specialty in which you might see that judge or appear in that court again and again, or in a particular small town, or even in a major city in a specialty. You might find yourself regularly appearing in front of a particular individual. Imagine the difficulty of shall meaning must, shall meaning will. It's tough, and hopefully it will never happen to any of us. But if it does happen, we have an obligation to these rules, and an obligation as officers of the court. So who do you bring the charges to? Well, the model rule says the appropriate authority, and hopefully your jurisdiction will spell that out in greater detail, because, a judge is in a courthouse that has a chief judge. Maybe that's as high as you have to go. Or a judge, of course, answers to a regulatory body. Maybe you've got to go to them. Hopefully your specific state rules give you more specificity than just that. The Model Code of Judicial Conduct also means that sometimes a judge has got to grieve you. What do I mean by that? Let's look at Model Code of Judicial Conduct 2.15. Here in subsection B, it says, a judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate authority. But I would point out that language again. Shall means must, shall means will, shall is an affirmative obligation, but the affirmative obligation is limited to those instances that raise a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So with the same caveats as seen earlier, talking about the model rules of professional conduct, those same caveats apply to this model code of judicial conduct, Rule 2.15. So has a judge committed an offense? If the judge sees a lawyer commit offense and doesn't report the lawyer? Not necessarily. Remember this, in almost all tribunals, the judge will have some inherent authority to control the courtroom or the proceedings. Almost always, that inherent authority includes the ability for sanctions, meaning punishments, meaning fines, or with appropriate jurisdiction, meaning imprisonment. What am I saying? Judge can throw you in jail, Mr. Lawyer. The judge can get the money out of your wallet and fine you, Mr. or Miss Lawyer. That might be the way the judge responds. And hey, that can hurt. When it comes to violations of the rules of professional conduct, there can't be a direct monetary fine other than costs of the proceedings. The monetary fine can be indirect, such as a suspension, which means you can't practice law for a given period of time, or a disbarment, which means you can't practice law ever, but not a direct, I fine you $10,000 or $50,000 or $100,000. The Bar Council, the Florida Bar, the DC Bar, can't make a direct monetary fine of that sort, but a presiding judge can, with appropriate jurisdiction, enter a judgment against you personally as the lawyer for $1,000, $5,000, $50,000, $200,000. So that's not only money out of your pocket, but what's going to happen to that judgment that fined you, that sanctioned you? It's going to have an exhibit sticker on the bottom. It's going to be attached to a bar complaint filed against you by Bar Council. So don't underestimate the presiding judge's powers. And don't misbehave in court. Under subsection D, a judge who receives information indicating a substantial likelihood that a lawyer has committed a violation of the rules of professional conduct shall take appropriate action. What might that appropriate action be? Might be sanctions, might be referral to Bar Council. So what's appropriate is going to be within the presiding judge's discretion. As an example, we've got Canon 3D, not three-dimensional, but number 3, letter D. Canon 3D of the Florida Code of Judicial Conduct, again, based upon the model code. A judge who receives information or has actual knowledge that a substantial likelihood exists that a lawyer has committed a violation of the rules regulating the Florida bar shall take appropriate action. So slightly rephrased, but same meaning and same effect as the model rule. You can find that in Florida Code of Judicial Conduct, Canon 3D. So where do bar grievances come from? Why do ethics investigations begin? Where are the sources? Sources of complaints against lawyers, they can include judges, as we just talked about. They can include opposing counsel, as we talked about just before that. They can include clients. Clients are a major source of grievances. And what's the number one complaint in most surveys of clients that causes the client to file the bar grievance, to complain about the lawyer to the bar? The number one complaint is a lack of responsiveness. Most surveys agree. Lack of responsiveness. Client calls, doesn't get the lawyer, leaves a message, doesn't get a return phone call, calls again, still can't reach the lawyer, leaves another message, doesn't get a return phone call, doesn't know what's going on in their case, doesn't know what's happening with their transaction, doesn't know what the next event is in their litigation. Out of frustration, they complain to the bar. So what is a lawyer to do? Obviously, be responsive. Sometimes easier said than done. There's all of us have times where we're busier than others. Hey, all of us, Lord willing, have times where we take a day off or we take a vacation. As your practice grows, you got to add staff. And nowadays, that's easier than ever. If you don't want to be an employer, you can outsource. You can get help. There are virtual receptionists that will answer your phone for you. Sound like a real receptionist, but they're actually working for 10, 20, 30, 50, 100 clients at the same time. But they answer the phone and they say, Law Office of You. Insert your name here. And then they reach you with a message. So maybe you couldn't get the call yourself, but you can have help doing it. Likewise, you can hire paralegals. Can't afford a paralegal? You can hire a secretary. Can't afford a secretary? You can hire a clerk. Can't afford them full-time? You can hire them part-time. Can't afford them part-time? You might be able to outsource something. For example, are you doing your own books? Keeping your own bookkeeping? Writing your own checks? Easily outsourced to a CPA or a bookkeeper. So you can make yourself responsive by getting some help. What's another source of complaints against lawyers? Bar counsels themselves. Maybe your misbehavior made the newspaper. Maybe there was an anonymous tip. Can happen. Model Rule 8.1 talks about disciplinary matters. Disciplinary matters, such as bar admission, and disciplinary matters, such as wrongdoing after being admitted to the bar. Take a look at this part of Model Rule 8.1. A lawyer in connection with a disciplinary matter shall not knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority, except that this rule does not require disclosure of information otherwise protected by the confidentiality requirements such as Model Rule 1.6. Let's break that down, shall we? Say someone has filed a grievance against you, or bar counsel has instigated an ethics investigation about you. Well, where's the information going to come from for bar counsel to win bar counsel's case? Well, in a lot of instances, that information is coming from you. So bar counsel is going to ask you for documentation. And depending upon the rules of your particular jurisdiction, it may be as formal as a subpoena. In other jurisdictions, it may be as informal as an email, a phone call, or a letter. But if you knowingly fail to respond to a lawful demand for information, that itself becomes a separate offense to be prosecuted. So the dastardly might think, oh boy, the smoking gun is in my possession. I'm going to get rid of the smoking gun. Well, all that dastardly person has done is changed the nature of the charges. Now they're charged with wrongful disposal of a smoking gun. So when you join a bar, one of the obligations that you assume as yours, you assume the obligation to respond to ethics inquiries. Now, of course, you can't help but feel you should have your guard up, but you can't behave that way. You've got to respond to each lawful demand for information. Is there an exception? Well, yeah. Model Rule 1.6 talks about the attorney-client privilege, talks about rules of confidentiality, and likewise, rules of civil procedure or other statutes, be they evidence code or otherwise, in your jurisdiction, will make certain information known to you or in your possession confidential under the law. That information might be something that you don't have to provide in response to a lawful demand for information. But practice tip. The right way to go about this is, is in the nature of a privilege log, by which I mean you provide a list of what it is that's in your possession or your knowledge to bar counsel without spilling the beans, without violating confidentiality, without giving away the information, but identifying what you've got with enough specificity that the confidentiality is preserved, but bar counsel can see that there is a lawful confidentiality concern. And in every jurisdiction, if you and bar counsel can't agree, there'll be a way to resolve that disagreement. For example, here in Florida, if I'm defending a client and bar counsel doesn't agree, often we can go in the early stages to the grievance committee and they can vote. If not the grievance committee, then I can go to the Supreme Court of Florida as referee. The referee can decide. But there'll be a way in your jurisdiction to resolve these things other than hiding the smoking gun, finding yourself charged with worse than a spoliation of evidence complaint with a bar violation for not having responded to a lawful demand for information. That's true also when it comes to applying for membership in a bar. It's a violation that can be charged after you become a member, that during the membership application process, you failed to respond to a lawful demand for information. Or you might just get denied admission for having done so. But if somehow you did the wrong and you got the membership, you might find yourself disbarred. So if you're an applicant, get it all out there. I've been asked, and I don't represent applicants, I represent lawyers, but I've been asked, I'm not sure what the application is asking. Maybe this fact about me is included, maybe it's not. My advice has been, write that down. Not sure exactly if your question includes this information, but here it is, and give it to them. That shows that you don't lack moral turpitude, that you're not trying to hide the smoking gun. Again, I don't represent applicants, but I've given that advice. Florida Bar Rule 4-8.1 is based on that model rule 8.1. And it says that a lawyer, in connection with a disciplinary matter, shall not knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority, except that this rule does not require disclosure of information otherwise protected by the confidentiality of Rule 4-1.6. So as you can see, that's substantially the same as the model rule. But wait, there's more, because the Florida Bar Rule goes much further. You find this in 4-8.4, but it matches up well with the requirements of 4-8.1. A written response shall be made within 15 days of the date of the initial written investigative inquiry. So when you get from ACAP, our attorney-client assistance panel, when you get from ACAP in Tallahassee that initial news that someone has filed a grievance against you and the bar deems it worthy to bother you for a response, you've got 15 days. Now, in my experience, can you get an extension? Yes, if you ask for it. I would advise asking for it before the 15 days is up. So you can get an extension, but don't ignore it, because it's a rule violation to miss the deadline. Also under Florida Bar Rule 4-8.4, sub 2, a written response shall be made within 10 days of the date of any follow-up written investigative inquiries. So you make a 15-day deadline, but that made them ask for something else. Now you got just 10 days to give them that follow-up. Again, you can ask for an extension, they can grant it, but you're best to ask for it before the deadline expires. 4-8.4 sub 3 says a written response shall be made within the time stated in any subpoena issued under these rules. Now, you'll note from 1 and 2, you've had to cough up anything or almost everything without the formality of a subpoena. But You can also be subject to a subpoena, so can a third party. 4-8.4 sub 4 says that a written response shall be made as provided by the Florida Rules of Civil Procedure, and 4-8.4 sub 5 says a written response shall be made as provided in the Florida Rules of Appellate Procedure. What's that mean? Well, as you litigate against the Florida Bar and its Bar Council, if you miss a deadline within that litigation, in other words, you didn't respond as provided in the Florida Rules of Civil Procedure, the missed deadline within the litigation itself can be a separate grievance. Ouch. No wonder folks hire me to help them, right? So as you're trying to defend yourself, a missed deadline in your defense of yourself can become another separate additional charge against you. So as you can see, the Florida Bar Rules have expanded greatly upon Model Rule 8.1. They did so in 4-8.1 and in 4-8.4, and they expanded greatly upon these requirements. And why is that? Well, anytime a lawyer faces a grievance, they get their lawyer up, they get their guard up. I'm going to hit them with a technicality. I'm going to keep them from getting this, keep them from getting that, keep them away, keep them at bay. That's not the behavior that is admirable. We're part of a profession that's self-regulating. So if we ourselves are going to regulate ourselves, we got to cooperate with ourselves, or stated somewhat differently. If we're going to remain a self-regulating profession, we got to have a system that works. The public deserves nothing less than a system that works. If we're going to degrade our self-regulating system into something that doesn't work, then the public might and probably should step forward and replace the self-regulating with regulation by an outsider. And think about it. How many professions can claim self-regulation? You walk into the supermarket, you're buying a steak. What does it say on it? It says USDA grade A. Who put the grade on there? The USDA, the U.S. Department of Agriculture. Was it the farmer? Why doesn't it just say farmer grade A? Why don't we let the farmers regulate themselves? Oh, we don't do that. No. We want the government involved. We don't want people who sell me a steak to tell me how good the steak is. How much more important are legal services than the quality of a steak? How much harm would the public suffer if they thought they were buying grade A steaks but only got grade B? We put government regulation on top to make sure that harm doesn't happen. But yet, it's so much more important that the public, no disrespect to farmers, that the public get quality legal services. And yet we let the lawyers regulate themselves. If the public is going to continue to tolerate the self-regulation of the lawyers, then the regulation of lawyers better be among the best regulation, because the public deserves nothing less, and a wise public will tolerate nothing less. So this is one way that one bar, the Florida Bar, has come forward to make sure that the self-regulating process continues to work and continues to work in a timely fashion. Did I just say that the Florida Bar works in a timely fashion? I can't say that that's always the case, but rules like this at least indicate an intent to do so. I'd say at least an intent, huh? Florida Bar Rule 4-8.1 says that a lawyer in connection with a disciplinary matter shall not commit an act that adversely reflects on the applicant's fitness to practice law. And that goes back to when you're facing an ethics investigation. You're not expected to turn yourself into a boxer. You're supposed to cooperate and help maintain the self-regulating nature of our profession. That was some pretty poor boxing that I gave an example of, right? Good thing I became a lawyer, not a boxer, huh? Okay. Hey. All right. So a lawyer connection with disciplinary matter should not be behaving in such a way that adversely reflects on the applicant's fitness to practice law. And hey, it's the wrong time to be violating the rules regulating the bar, right? When the bar is investigating you, when they're actually looking at you, at your behavior, not the wisest time to be unprofessional or unethical. Let's take a look at Model Rule 8.2. This rule talks about judicial and legal officials. Now, does a lawyer have freedom of speech? We know there's a U.S. Constitution, right? We know that it has a First Amendment, right? We know that it talks about freedom of speech. Indeed, your state constitution may also talk about it. Article 1 of the Declaration of Rights of Florida's Constitution talks about freedom of speech. So what about lawyers? Do lawyers have a constitutional right to freedom of speech? And of course, the answer is yes. You remember the case of Bates versus State Bar of Arizona, where the Supreme Court of the United States said yes, freedom of speech applies to lawyers. Bates versus State Bar of Arizona was talking about whether a lawyer can make truthful statements in the form of commercial advertising. And a lawyer can. But as you know, advertising can be regulated. Speech can be, within the confines of our Constitution, regulated. So what about a lawyer's speech about judicial and legal officers? Can it be regulated? Well, if we look at Model Rule 8.2 and the comments there, we see the motivation for motivating the speech of us lawyers when it comes to judicial and legal officers. Assessments by lawyers are relied on in evaluating the professional and personal fitness of persons being considered for election or appointment to judicial office and to public legal offices such as Attorney General, Prosecuting Attorney, and Public Defender, says paragraph 1 of the official comments to Model Rule 8.2. And they're right. You know, if you want to know whether the foot doctor down the street is a good foot doctor, probably ask other foot doctors, right? If you want to know whether the dentist on the corner is a good dentist, you might ask another dentist, right? If you want to know whether a candidate for judicial office would make a good judge, you might want to ask a lawyer. So this is the rationale for impeding upon pure free speech. What the rule says here is that a lawyer can't make a statement that the lawyer knows is false, or the model rule continues, with reckless disregard as to its truth or falsity, if that statement of the lawyer is about the qualifications or integrity of a judge, adjudicatory officer, or public legal officer. Yeah, I see your concern. The First Amendment, freedom of speech, certainly is a prior restraint upon that free speech. And you know, for that reason, you see modifications to this Model Rule 8.2 when it is enacted by the states. Sometimes you see modifications that scale it back. Sometimes you see modifications that make it more broad. Although it hasn't been adjudicated or put to the test, arguably Florida's version of 8.2, which would be Rule 4-8.2 of the rules regulating the Florida bar, extends this to even more individuals that you can't speak ill about, including certain members of the bar. How far will the Constitution allow our freedom of speech as lawyers to be impeded? Time will tell. What we know now when it comes to Model Rule 8.2 is that if the lawyer knows it's not true, or if the lawyer is just being reckless with regard to whether it's true or false, and the statement concerns qualifications or integrity of a judge, adjudicatory officer, or public legal officer, or a candidate for election or appointment to judicial or legal office, then that statement can be a basis for Bar Counsel to bring charges under Model Rule 8.2. Model Rule 8.2 also impedes the free speech of a lawyer who's running for judicial office. What I'm talking about is a lawyer who wants to be a judge, not a lawyer. So the lawyer who wants to be the judge has to comply with the applicable provisions of the Code of Judicial Conduct when it comes to how the lawyer conducts her or himself and conducts and says what she or he says while running for office. Obviously, First Amendment concerns are implicated here, and that should be a valid concern of all of us. So I note those concerns, and I give you the model rules language, and I point out that states have modified that language when enacting this particular model rule. Interestingly, returning now to those official comments of the ABA's Model Rule 8.2, paragraph 2 is a short one sentence that says the following. I'm reading it to you verbatim because I got my reading glasses on. When a lawyer seeks judicial office, the lawyer should be bound by applicable limitations on political activity. So maybe going even further into First Amendment rights, freedom of association perhaps, some judges, such as many judges here in the state of Florida, instead of being appointed, are elected. That may or may not be true in other jurisdictions. And the question becomes, can the judicial candidate identify their party affiliation? I'm talking about political party, Democrat, Republican. I know there are other political parties that are not coming to mind at this moment. Political party affiliation. So what the model rules are suggesting is that perhaps that particular First Amendment right might also be regulated. So time will tell as to exactly what the courts have to say about these potential constitutional limitations and violations. But now let's look at Chapter 6. We just finished covering Chapter 8. Chapter 6 talks directly to our theme of the night, talks directly to the theme of public service. And ABA Model Rule 6.1 talks about voluntary pro bono publico service. And of course, we're all familiar, with pro bono. It was the 1980s, and their album, The Joshua Tree, was released to great fanfare. And then perhaps one of the greatest albums ever released, Achtung Baby, and rose to pop stardom, but also to prominence as an activist, as a public servant, was their lead singer and frontman, Bono. And because either the great music or the great public works, we are all pro bono. Sorry. We weren't talking about Bono. No, pro bono. I always mix those two up. I'm a big U2 fan, as you can tell. So whether or not you're pro bono, which you should be, the guy is great. You should also be pro bono. What are we talking about when we talk about pro bono? Well, pro bono, we're talking about working for free. Now, there are a lot of professions out there that aren't the law profession, and I don't know how many of those go around shaming their members into working for free. For example, I don't know how much free services you've gotten from your hair cutter. I could use a trim. Usually you got to pay for your haircut, right? I haven't seen a lot of free services at my hair cutter. Maybe you've seen it at yours. I don't know. Accountants. I guess there's tax clinics sometimes, but not a lot of free bookkeeping services, for example. A lot of professions, they're not really focused on giving away the services of their members. But hey, when it comes to lawyers and lawyering and attorneys at law, we're quite proud of our pro bono, And it's a beautiful thing because we have to serve the poor. Whether you're a lawyer or you're not a lawyer, the poor have to have an esteemed place when it comes to serving your fellow man, woman, and child. We've got to look out for the poor. And pro bono is one of the many ways we can do that. We should be proud of our profession. I'm certainly proud of the legal profession. I hope you are too. And one of the things we can be proud of is this emphasis on pro bono. Now, with that said, are we required to do pro bono? No. Can we be subject to discipline for failing to do enough pro bono? No. The model rules encourage pro bono service, but they don't make the lawyer subject to discipline for failing to either do enough or to do any pro bono service. So as proud as we can and should be of pro bono, let's not toot our horns too loudly, because it's still a voluntary act, for better or for worse. As well as being voluntary, practice note for you, I think you should choose wisely when it comes to who you serve, who you provide pro bono to, what kind of pro bono work you do. Have you ever been yelled at by a judge for having done pro bono work? I won't reveal a name so as to protect the innocent, but yours truly, more than 14 years ago, was standing in front of a bankruptcy judge on a motion to withdraw, explaining that I had been doing the work for the debtor pro bono. Boy, did I get yelled at. The judge was right. The judge was right. She said, pro bono is down the street. She was indicating the direction of legal aid. That's where the pro bono is done. When it comes to the bankruptcy law, as many of us know, it's structured in such a way, set up in such a way, that the administrative cost of the lawyer who represents the debtor ultimately is paid from the assets of the estate, ultimately is paid from the money that would have gone to the creditors that took the risk of extending credit, and now, unfortunately, that risk didn't pay off and they find themselves in a bankruptcy court. Judge was right. I'd chosen poorly as to who to provide pro bono services to. Now, with that said, I've also been praised for doing pro bono work. It was not that long ago. It was December of 2019. The Legal Aid Society of the Orange County Bar wanted to thank me for my years of service, give me a certificate, and come before their board there, their board of directors, their head honchos. When they told me that, I actually said, can I bring my wife? And they said yes. So I brought Bernadette, because this is our 15th year of marriage. I've been telling her for almost 15 years that I ain't such a bad guy. I'm an okay guy. And I thought maybe this could help me prove my case if she was there when they handed me the award, which she was. So I didn't deserve the award, as I said when I received it, because so many people do so much more than I do over there. But at least in that instance, I wasn't yelled at for doing pro bono work. And I would encourage you to likewise do your fair share. I don't know whether I do my fair share or not, but we should all do our fair share. I think we can agree on that. So what do the model rules tell us about pro bono work? The model rule 6.1 tells us that every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should aspire. Should is not shall. Should is not must. Should is not an affirmative obligation. Should is a unenforceable lofty goal. A lawyer should aspire to render at least 50 hours of pro bono public legal services per year. Last statistic I saw is a little out of date, but on a nationwide basis, lawyers were not hitting an average of 50 hours of pro bono public legal service per year. Maybe the statistics are better once they're updated. That was Model Rule 6.1. That was the basis of Florida Bar Rule 4-6.1. There, it says, the professional responsibility to provide pro bono legal services, as established under this rule, is aspirational rather than mandatory in nature, just in case you missed that from the shall. The failure to fulfill one's professional responsibility under this rule will not subject a lawyer to discipline. Wow. Wow. They really went out of their way to spell out the difference between must and shall, didn't they? Yeah, it doesn't stop there. 4-6.1 of the rules regulating the Florida Bar says the professional responsibility to provide pro bono legal service to the poor may be discharged by one or two. One, annually providing at least 20 hours. What? Didn't the model rule say to aspire for 50 hours? Annually providing at least 20 hours, not a typo. At least 20 hours when 6.1 model rule became Rule 4-6.1 of the rules regulating the Florida Bar. So option 1 in Florida is to annually provide at least 20 hours of pro bono legal service to the poor, or option 2, make an annual contribution of at least $350 to a legal aid organization. Florida Bar has a biannual survey. Not every lawyer, of course, is paid by the hour. But those surveyed biannually who receive an hourly rate, more than 30% of them charge more than $350 per hour. For many Florida lawyers, this requirement is less than an hour's pay. So when Model Rule 6.1 became 4-6.1, I think it might be fair to say that the requirements were scaled back, and it might be fair to say that they highlighted the fact that they're not requirements at all. So may, not must, may be discharged by either 20 hours of work or something that might be, depending on the lawyer, as low as 1 hour's wage. Does the rule regulating the Florida Bar say what it means? According to the courts, it does. For example, look at Schwartz versus Kogan, which came out of the 11th Circuit in 1998. Quote, Florida Rule 4-6.1 urges members of the Florida Bar to render 20 hours of pro bono legal work to the poor or contribute $350 annually. This is aspirational only, held the court. And of course, you saw the language of the rule. The holding is correct. Something else to note about the holding. That was the holding in 1998. Back in 98. Far more than 21 years ago. Back in 1998, we were asking people to do 20 hours or pay $350. Over the past 21 years, neither one of them went up. Maybe arguably, hours are hours, whether those hours are performed in 98, 2008, or 2018, but $350 today doesn't have the buying power that it had back in 1998. But yet, no increase in the rule. Florida Bar Rule 4-6.1 talks about pro bono service. It also says this: in the event that more than 20 hours of pro bono legal service to the poor are provided and reported in any 1 year, well, then the hours in excess of 20 may be carried forward and reported as such for up to 2 succeeding years. Did 60 hours this year? Take a 2-year vacation for pro bono. seems to be what the rule suggests you can do, not that you have to. 4-6.1 of the rules regulating the Florida bar also says each member of the bar should strive to individually satisfy the member's professional responsibility to provide pro bono legal services to the poor. Collective satisfaction of this professional responsibility is permitted by law firms only under a collective satisfaction plan that has been filed previously with the Circuit Pro Bono Committee. What's that mean? If the firm's big enough, it takes the time to write up the plan and get it filed, then all the busy partners can do zero pro bono. We can have the newly hired associates do all the pro bono for the firm, and the entire firm gets credit for the associates' work. So that's pro bono. And the model rule, it's what? Aspirational only. Each state can modify that when they enact a rule, and indeed in Florida. There certainly were some modifications. The modifications included spelling out in great detail that there are no requirements to do the pro bono work. In fairness, the rules regulating the Florida bar do have a requirement when it comes to pro bono. You're required to report how many hours of pro bono you did in a year when you pay your bar dues once a year. On the form, you have to put down, if it was 0, you put down 0, you won't be punished for that, but you have to give an answer. Back when the form was primarily submitted on paper, I guess you could violate that rule. You could forget to write the number on when you signed in and your check and mailed it in. But of course, nowadays, you can do that online. And if I remember correctly, I hope I'm not misremembering this, because I only do it once a year, just like every lawyer does it once a year as a member of the Florida bar. I don't think you can hit submit unless you fill out that line. So it's probably, if you pay online instead of on paper, it's probably not practically possible to violate the one and only required pro bono rule under the rule regulating the Florida bar, that being the requirement to tell them 0 or 1 or 20 or 10,000 hours or however many hours it is. That was the number of hours served by you. So that's pro bono. Where do you stand? Are you pro bono? Will you do your part? Will you help the poor? Will you choose wisely and make sure that you're helping the poor in a situation where there wasn't other assistance available to the poor already? Will you do your part? Will you do at least the number of hours that your jurisdiction believes should be the minimum? Are you a person who just does the minimum? Do you go above and beyond to help your fellow man, woman, and child? These are personal questions that only you yourself can answer. And I hope you'll answer them well. Moving on now to Model Rule 6.2. This talks about accepting appointments. And what we're talking about here is being appointed as counsel. Not that you chose the client, but that it was chosen for you. Let's take a look at some of the model rules language. It says here that a lawyer shall, that's mandatory, that's will, that's must, that's an affirmative obligation. A lawyer shall not seek to avoid appointment by a tribunal to represent a person except for good cause. Now, good cause isn't limited to the ABC list you see on the big screen behind me, because the list begins with the phrase such as. So this is a non-exclusive list. Good cause might be such as A, representing the client is likely to result in a violation of the rules of professional conduct or other law. Wow, shouldn't that have gone without saying? Could be B, representing the client is likely to result in an unreasonable financial burden on the lawyer. Or C, the client or the cause is so repugnant to the lawyer. Now, the model rules, and I know the DC Bar rules, state that merely accepting representation is not to be interpreted as agreeing with the positions, the attitudes, the opinions of the client you represent. That's important because it's not just the beloved and the beautiful that need lawyers. Sometimes it's the repugnant, the not so beloved, the not so beautiful, the controversial that need lawyers. Many of our rights are established and enforced and illustrated through cases where the repugnant, the ugly, the disgusting are still having their rights upheld. Justice is blind is the cliche. Justice is blind is the goal. Justice is blind is what's required if these rights are going to mean anything. Earlier in our discussion, one of the rights we talked about were those First Amendment rights, such as freedom of assembly, freedom of speech. The misinformed will often say, well, that was hate speech, so it's not protected. That's misinformed. That's wrong. The misinformed might sometimes say, well, that is offensive speech, so that's not protected. The misinformed are mistaken. The misinformed are wrong. It's not the beautiful speech that's in most need of protection. Who's striking out to shut down beautiful speech? It's the speech at the periphery, the speech that is ugly, the speech that is, perhaps the speech that is repugnant. That's in most need of protection. And how can it get that protection? Only if it can get a lawyer. Was it not Voltaire who said, I may not believe in what you say, but I will fight to my death for your right to say it? It's the repugnant client who can be in most need of our legal services, not because we believe in what they say, but because we're willing to fight for their right to say it. So, can you decline an appointment where you've been unwittingly appointed by a judge because the case is repugnant? Yes, you can. But should you? That's the question you need to answer. 2 quick rules to cover before we wrap up our lecture. Thank you for putting up with me for these almost 90 minutes. I just wanted to mention Florida Bar Rule 12-1.3. 12. Talks about an emeritus attorney. So this is an attorney who's been an active attorney, but is no longer an active member. They've changed their membership to inactive. So an emeritus attorney in association with an approved legal aid organization and under the supervision of a supervising attorney can help provide some services. For example, number 1, they could appear in any court or before any administrative tribunal in the state on behalf of a client of an approved legal aid organization. Or number 2, the emeritus attorney can prepare pleadings or other documents to be filed in any court or before any other administrative tribunal in the state in any matter in which the emeritus attorney is involved, but the supervising attorney must also sign. Or number 3, may engage in such other preparatory activities as are necessary, such as meeting with the client, advising the client, helping the client make a decision, informing the client of their rights. So I'd be remiss if I moved on from this lecture of public service and maintaining the integrity of our profession if I didn't illustrate an addition in the rules regulating the Florida Bar that does not appear in the model rules of professional conduct. Now, you can decide for yourself, maybe it shouldn't, maybe it should, but certainly this is an attempt by the Florida Bar to provide additional public service and to maintain the integrity of our profession in such a way that a mostly retired or semi-retired attorney can still be doing pro bono work. Something to think about, model rule drafters. And it's right here in my beloved state of Florida. I also love the District of Columbia, proud to be a member of their bar too. And the District of Columbia rules of professional conduct contain Rule 9.1, which does not appear in the model rules of professional conduct. ABA model rules of professional conduct drafters, pay attention. Read this rule from my beloved DC bar. 9.1 of the District of Columbia rules of professional conduct says a lawyer shall not discriminate against any individual in conditions of employment because of the individual's race, color, religion, national origin, sex, age, marital status, sexual orientation, family responsibility, or physical handicap. Yes, we have civil rights laws that cover such things. And yes, as we began our lecture with the catch-all, if you will, of ABA Model Rule 8.4, violating civil rights would certainly fall under 8.4. But to make it inarguable, to make the burden clear, to make it part of our professional responsibilities, the model rules could contain, and the DC Bar rules do contain, this explicit restriction when it comes to hiring and firing and employment decisions. Will you hear the clock? That means our 90 minutes are done. I've enjoyed them. I hope you've had too. In our next discussion, we will talk about practicing without a license and what it means to practice law. Until that lesson, may God continue to bless us all. Thank you, and have a good evening.